Can you hear me, Mr. Marco?
I can.
Is this going as a plea, Mr. Keen? Yes, I have a plea questionnaire from February 4th. Has anything changed?
No, Your Honor.
Not from the state's perspective.
We will go on the record in the matter 23 CF 169, 23 CT 58, 25 CF 97, State of Wisconsin versus Patrick Stewart Jr. The state appears through Special Prosecutor District Attorney Aaron Marco by video conferencing from his Washburn County office. We have Glenn Keen, defense attorney, appearing by video as well. We have Mr. Keen in person. We're set for a plea and sentencing hearing. Before we begin, Mr. Stewart, your attorney and Mr. Marco are both appearing by video conferencing. You can see them to the left on that big screen. Do you understand you have the right to say, you know what, Judge, I want everybody to be in the same room?
Yes, ma'am.
Are you okay with them appearing by video conferencing?
Yeah. Yes.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know. I will put you in the Zoom room or have you give him a telephone call so you can have a confidential discussion with him, okay?
Yes.
So we're here for a plea and sentencing. Mr. Keen, please recite the agreement that's been reached.
Yes, Your Honor. It calls for Mr. Stewart to plead to the OWI 3 and 23 CT 58 and to an amended THC to misdemeanor THC in 25 CF 97 with all remaining counts dismissed and read in. It'd be a joint recommendation of 12 months probation in 25 CF 97, OWI 3 guidelines in 23 CT 58, but that would be lowered because Mr. Stewart completed the IDIP program.
And what is his jail credit? I know that has been brought up.
Your Honor, I filed that in document 23 CT 58 on February 4, document 54. I'm tracking 18 days credit. The reason I had filed it that way is because at the time it was believed that Mr. Stewart's custody is not that 48 consecutive hours for the monitor, but he was on bond on all these cases from June, in custody from June 24 through July 9th.
Okay, so you're counting 18 days credit.
Yes, Your Honor.
18 days of credit. And this is an OWI third. And we have, is this a BAC case or is this a this is restricted controlled?
Oh, sorry, I'm just pulling that out.
Yeah, I believe that it is.
Restricted controlled, so there would be, if the court follows the guidelines, it'd be 45 days of jail, and you would be requesting to serve that by monitor?
Yeah, I do not have the funds.
You do not have the funds?
Yeah, the full funds for that, so.
Okay, so then you would be sitting in jail?
Yeah.
Okay,
Well,
and you know that it's an immediate report today?
Yeah, unless some of that bail money goes towards that, or could go towards that. I think there's a substantial amount of bail that's available.
Yeah.
Well, the bail was
2,000.
forfeited. Go ahead. Yep. And that's something the court would have to decide, but it wouldn't be decided here today either. Well, either way, you would have to go and report to, oh, you're asking about the bail that you've actually posted?
Yeah.
Either
Yes.
way, you would have to report to jail today unless Tessa Anderson has been contacted and she has a monitor at hand and
Okay.
she's ready to go that way. So has Miss Anderson been contacted?
About today, I don't believe so. I think she was the last time that we had court.
Okay.
So.
All right.
Yeah,
All right. So then you would be reporting today, asking the court to, with the money that you have posted for cash bail, asking the court to have some of that or all of that, well, not all, but some of that go to pay towards the jail.
Yes, ma'am. Yep.
Okay. All right. And Mr. Marco, as the district attorney here for the state, do you have any objection to anything that's been stated so far?
No, I believe that's all accurate. I think this is probably the second or third one of the OWI cases that I've had that I took when I took the batch of cases from Attorney Schmidt to help out in Burnett County. I know that you guys operated a little differently than we do. We've been through that a couple of times, so I would like Mr. Stewart to be treated as much as he would under the normal Burnett County processes, as anybody else would.
And I appreciate that, and that's exactly how it should go. I'm just curious how we do it different than Washburn.
We don't do any reductions, as far as the jail amount goes. We just do electronic monitor for the guidelines after completion of the IDIP. My understanding from the last one is that's slightly different than what, the Burnett County program is. So I think there's a slight reduction in the jail component.
Oh, you follow
amendment.
district guidelines.
Correct.
Okay, you follow district and we have our IDIP guidelines. Okay, all right, I get it now. Okay, yes, we have IDIP guidelines because you're doing a program and you're, it's a lot of work, and okay, so we appreciate that. Okay, so all right. So I have in front of me the plea questionnaire waiver of rights form, and he's pleading guilty to an amended count of possession of THC. And which case is that? Is that the 25 CF or is that 23 CF matter?
25 CF 97 count 2.
All right, formal motion to amend count 2 to a simple possession of THC.
So moved.
Granted. All right, so Mr. Stewart, I have in front of me that plea questionnaire waiver of rights form. Do you want me to print it out for you?
No, that's okay.
And so you recall everything on that document,
Yes.
and your attorney thoroughly went over that document with you,
Yes, ma'am.
essentially word for word.
Yes.
And attached to the document, he has what the state would have to prove beyond a reasonable doubt, as well as, I believe he has the maximum, no, he doesn't have the maximum penalties, but what the state would have to prove.
Yes.
And he also has attached the email that says 18 days of jail credit. And I think that's about all it says from the jail staff. And you remember that?
Yes.
Okay, so you're 49 years old, you have 12 years of schooling, and you can read, write, you understand the English language?
Yes.
And did your attorney thoroughly go over this document with you, essentially word for word?
Yes.
And you signed that document?
Yes.
And you signed it as of January 28th, 2026. Has anything changed from that date and time?
No.
And again, I can print it out if you want it printed out, just let me know.
Okay, I'm good. Thank you.
Okay. Now, no drugs, no alcohol, no medications, no mental illnesses or disorders, correct?
Correct.
And your attorney thoroughly went over with you, again, what the state would have to prove?
Yes.
And did he go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that plea questionnaire, the first page. Did your attorney thoroughly go over that with you?
Yes.
And do you understand that completely?
Yes.
Do you need me to go over your rights with you in any more detail?
No, ma'am.
So do you understand that you would be giving up those rights by pleading guilty here today?
Yes.
Okay, now, you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand that the state would have to prove on or around June 23rd, 2025, you possessed a substance. The substance was a controlled substance, THC, and you knew or believed that substance was a controlled substance, THC. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or imprisonment of up to 6 months or both?
Yes.
Do you understand in the 23 CT58 case, the state would have to prove on or around June 10th, 2023 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of a controlled substance, and this would be your third countable offense. Do you understand what the state would have to prove?
Yes.
You understand the maximum, well, the minimum you could be fined is not less than $600, but no more than $2,000, or imprisoned not less than 45 days, but no more than 1 year in the county jail. Do you understand that?
Yes,
And do you understand that upon conviction, the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an OWI AODA assessment and follow through?
yes,
Now, do you understand that there's an agreement here for the court to follow with 12 months of probation and to follow the OWI Third IDIP guidelines? Do you understand that?
yes,
Do you understand that I'm not bound to follow that? Meaning I could sentence you to the maximum penalties for both of these crimes if I thought it was warranted?
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Did you go over both of those criminal complaints with your attorney?
yes,
In particular, there's those sections called the probable cause sections, where it basically says what happened those days and why you were charged with the crimes.
yes.
For the most part, are those facts accurate?
Sure, yes,
Yes. So I'm just asking, did you possess THC?
allegedly, yes.
Well, I don't
Yeah.
want to know allegedly. Did you or did you not? Because you're pleading
Um,
guilty to it.
Well, it has to be on which day that was. I mean, because there's like 3 of them, right?
Right. Okay.
yeah,
So
so-
on one of these days, at least you
Sure,
possess THC.
yes, yep,
Yep. Whether or not it's that June 23rd, 2023
Yep.
5 date.
yes,
So one of the dates that you were charged, one of these things you possessed THC.
yes, yes,
Okay. And as it relates to the OWI Third, on June 10th, 2023, for the most part, are those facts accurate?
yes,
You operated with a restricted controlled substances detectable amount?
yeah,
Okay. So you're pleading guilty to both of these crimes because you are guilty?
yes,
Okay. Mr. Keen, may the court use the probable cause sections in the criminal complaints to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
no, ma'am,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yep,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes, very
Has-
thorough,
And so has he looked at this matter thoroughly?
yes,
And are you satisfied with his services?
very much so,
And so he's went over all of the facts of all of these cases with you thoroughly?
yes,
And he's looked to see
repetitively.
if you have any defenses or a lack of defenses in the case?
No, I think we went over everything thoroughly, yes,
And he discussed whether or not, if you go to trial, this could happen and this could happen?
yes, ma'am,
And so you are satisfied with his services?
yes, very much so.
Do you have any questions for the court or for your attorney before I proceed?
I do not,
As to amended count 2 and 25 CF 97, possession of THC simple, how do you wish to plead?
guilty,
As to count 1, OWI Third, are we doing, is it the OWI Third or the operated with restricted controlled? It's the OWI Third, that's what's listed. So with that OWI Third, how do you wish to plead?
guilty,
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 counts. The remaining counts and cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Marco.
Thank you. And first, looking at Mr. Stewart's prior criminal history, pulling it back from CCAP, it does go back quite a ways, all the way back to 1996 with theft and bail jump. There was a meth in 2012, domestic battery in 2012, reckless endangerment, and another battery. The reckless endangerment was in 12. The second battery was in 13. Then we jump up to 2017. There's a criminal damage to property. 19 is the possession of amphetamine, paraphernalia in 22. And then we get to these cases. So he hasn't had any other cases in the last several years. Looking at these cases, they are marijuana related. He was pulled over for a damaged windshield and a loud exhaust upon discovery and investigation by the officer. He found that he believed he was under the influence, blood draw, and then found to have a detectable amount of restricted controlled substance, the 9-THC, in his possession. And he admitted on at least one of the occasions that he also had THC in his possession. Looking at his criminal history over the course of time, going back all the way to the 1990s, it shows that there's some level of substance use and substance abuse that's been prevalent in his life. At this point in time, I don't believe that jail is just going to simply lock that out of him. I know that I think Mr. Keene, in the course of this case, said he just recently got off probation or had recently done something like that. I think continued supervision and trying to get him with a little more education, a little more classes, continuing to get him in that correct direction is what's going to be best to help protect the community. These are serious offenses. Anytime you're driving under the influence, you put everyone in danger that's on the road, including yourself, every vehicle you pass by, every pedestrian that you pass by. Marijuana, we can talk about all day long, whether it should be legal or whether it shouldn't, but the fact of the matter is that it isn't. And it's still a substance that alters the state of mind, still affects your ability to drive, and is illegal in the state of Wisconsin. So looking at these cases as a whole, I do believe that would be appropriate for him to be placed on probation at this time. And since he completed IDIP, to receive a sentence that's in accordance with Burnett County's IDIP guidelines. Thank you.
All right, thank you. Mr. Keene.
Oh, I would agree that the joint recommendation adequately reflects the gravity of the offenses. It provides an incentive, as Burnett County has done and some others do, to encourage people with substance abuse problems or alcohol problems who are on the road to proactively participate in programming before sentencing, along with doing a little bit of restorative justice with the 25 hours of community service. Mr. Stewart has complied with that. And his biggest problem when I represent him was just not showing up to court rather than, more activity. And then, of course, what happens, he didn't report to court. And that's when he's found with the marijuana in possession at his house. And, Mr. Stewart has been, making his court appearances, since late last year. He's also, along with, doing the work in the IDIP program, he's also enrolled in school to, for business. He's, trying to, he's had to take care of things with family members, and, he's having to, step up more and take on some of those responsibilities due to the health issues with his parents. And he, he's trying to show that he can comply with probation for a modest amount of time to show that he's, not going to be someone in his future who, continues to need supervision from the courts or probation to, conform his conduct to law. And I think that the agreement is a reasonable one that reflects all of the sentencing factors.
Thank you. Mr. Stewart, is there anything you want to tell me? You want to let me know about this, that, and you?
I would like to thank everyone that was involved last time for giving me that extension for my court date for personal matters. So I appreciate that. Like Mr. Klum said, that I'm going to school for business management, Northwoods. I got the IDIP completion. I've already did my victim witness panel. Started my driver safety plan with Erica through Aurora. So I've gotten quite far with that. I think we've been doing that for 3 or 4 months. So yeah, the ball's rolling in a forward progression.
Excellent.
Right.
So are you going to business school? Because don't your parents have a campground or something?
Yeah, yep, I'm
Take
yellow.
over the campground?
I'm not sure about that. I did that on a more personal level. Just to be able to, you hear about everyone making money and then letting somebody else mess with their money, and then how that's not a good thing. So if I plan on doing any kind of business, like starting a business of my own, I want to be able to dictate where that money is going, how it should go, and not lose it. So yeah, so.
That's very smart.
Right.
And I think that's good of you to do. It sounds like, and I don't mean this in a bad way, but you're 49 years old. It sounds like you're finally getting your life together.
Yeah, it's a slow start.
So start, but you're doing it.
Right, right.
And that's
Yeah.
a positive thing.
Yeah, school's 60 credits. So yeah, that's something.
Okay,
Something new.
I'm glad to hear that because that comes into play with all of these things. So obviously the OWI third is serious.
Mhm.
You can't operate a motor vehicle with restricted controlled substance in your system.
Right.
That's just the law. And especially if it causes any impairment while operating a motor vehicle. So it's serious. The possession of THC, not really as serious, but as Mr. Marco stated, it is against Wisconsin law. I
Right.
don't see it changing. I don't see it happening anytime soon. It's against the law. You can't use or possess, okay? So they're serious. You have a criminal history, moderately extensive criminal history, but you're trying to put your life back together. You're trying to be better and to go to school and to make something of yourself, which is all positive. And looking at protecting the community and looking at these cases, they're drug cases. It's an operating while under the influence of a controlled substance cases. You are putting the community at risk with operating with a restricted controlled substance. But for the most part, and the other matters, you're putting yourself at risk. You're putting that into your body, whether or not it is synthetic cannabinoid or it's regular grown THC or anything like that. You're putting that into your system. And I'm going to tell you, the marijuana of today is not the marijuana of the 60s.
Right.
It is so chemically engineered, and it back in the 60s, back in that day, probably not a bad thing. We just didn't understand it back then. But now
Right.
everything is so engineered and it's crazy, and you don't know what you're putting into your body.
Fact.
So that can be scary. With this case, you did the IDIP. I think that's very positive. So you're going to get that benefit. I'm going to order $1,286 in fines and fees, plus a $10 blood draw fee, 45 days of jail with 18 days of jail credit, 24 months of ignition interlock device, as well as 24 months of revocation of your driver's license, 25 hours of community service, but you've already completed that. So that's positive too. That goes positive in your favor. With the possession of THC, the court is going to order $200 in fines and fees, or just the DNA surcharge. I'm waiving the rest. You have lots and lots that you owe for the OWI. So I'm giving you a deal as it relates to that second count.
Thank you.
Waiving the rest. I will put you on probation for 12 months. Perhaps that could do you well, and it can help you when you're in school, because you know you have that hanging over your head and you have to go to school. You have to do those things and graduate. I'm going to do 2-month imposed but stayed sentence. So if you're revoked, you have 2 months to sit. I'm not going to hold 6 months over your head, and I'm not going to send you to jail right now with the THC. With the OWI third, I'll get to conditions in a second. With the OWI third, and at 45 days, you report today and immediately.
Mhm.
You will have money left over from your bond, from the bail you've posted, and that can be sent over. I can send that over to Dave Hatch and to Tessa, but I need them to tell me how much is owed, and you're going to need to prepay the rest.
Mhm.
And then at that time, I'm A-okay if they come hook you up and you're released on Huber with that, because I want you to go to school and I want you to do those things.
Perfect.
So I just need either Dave Hatch or Tessa to calculate how much is owed, and you need to be able to prepay that.
Mhm.
And then somebody can come and hook you up and have you on your way and doing the right thing. That does test 24/7,
Mhm.
and it does GPS. So you're going to be under watch. With probation, absolute sobriety, no use or possession of illegal drugs, substances, or paraphernalia, regular drug testing, gainful employment, or continued education, and you're going to be doing that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail will make sure that they take that. You would have the ability to request it be expunged through a written letter to the Department of Justice, not to this court, but to the Department of Justice. Again, Ms. Anderson's going to have to wait to see how much is left in bail
Mhm.
and how much we have here, and she and/or Dave will calculate how much you're going to need to pay. And then from there, you'll figure out how you have the rest of the money to be able to apply it to be put on house arrest. Strongly encourage you not to be around anything that has alcohol in it, gasoline, or any type of even cooking alcohol could set the machine off. Okay.
Okay.
And so I don't take an excuse about it was mouthwash or it was something else that went through my system and it set the machine off. I don't take that. You're going to be told to immediately report to jail to serve the rest of your time. No good time, no Huber. Okay.
Yep.
Report to probation immediately. Well, while you're in custody, you can probably call them and get it set up. Are you still on Highway G?
Yes.
Telephone ends in 8925.
8947
May I get the full number, please?
75475 8947.
All right, thank you. May we send you text messages if we need to?
Yes.
Anything I'm missing, Mr. Marco?
I don't believe so. Thank you.
Mr. Keen?
No, Your Honor, I just, for Mr. Stewart's info, since by the time they would get to it, would be tomorrow at the earliest, then he'd have around 14 days worth of IDIP fees. So just doing my math, I think he has enough to transfer over to cover the rest of it.
Well, yeah, we'll get that figured out. Okay, all right, so you must go report to jail immediately. Come get a form from Olivia, and then you can go report and we'll be good to go. Okay?
Thank you.
All right, thank you.
Thank you, Mr. Bloom.
We are adjourned.
Thank you. I believe that's it for me today.